Okay, I think we can start. So in this way, we can have the possibility, the chance to use our time for our discussion. Welcome to everybody again. I'm very happy to open this panel, this session. The title of our panel is Judgment: Perspectives from Law and Philosophy. And as you can understand immediately from our title, our aim in our discussion is to deal with the function of judgment in law. Above all, we would like to deal with the relationship that we could have starting from the topic of the judgment with the philosophical and theoretical elaboration that on judgment comes from other scientific field. I mean, aesthetics, ethics, politics, and not only law. With the one, inspiring idea, the idea that from this contribution from other fields is, from one end, to understand better the nature of the legal judgment, but it's also true, and maybe it will be shown within our section, that the legal judgment is able to enlighten, I could say, the nature of judgment also in other fields. And so there is an interconnection, I could say, between different fields. We have to deal with what difference, for example, legal judgment from other judgment. And in order to do that, we decide to link in particular two main legal field, legal and scientific field: the legal field of philosophy of law, of legal theory, and the legal field of criminal justice. For that reason, you find as speakers people coming from these two different legal fields. But knowing our very brilliant scholar that, except me, of course, that have been involved in this panel, I'm sure that you will find in every speech elements coming from both fields and also other fields. Our mind is very broad from that. Okay, I think that the best thing is to start. And as I anticipated before, we changed a little bit the order of presentation. So the first presentation will be from Angela Condello, then Paolo Sousa Mendes, then me, and then Stefano Ruggeri. Just 2 words about Angela, that is assistant professor in legal philosophy at the law department of the University of Messina. She's also adjunct professor at the Department of Philosophy, University of Turin, where she held a Jean Monnet module on human rights and critical legal thinking within the European legal culture until the fall of 2020. She has written a monograph on different fields, of course, of legal theory, relationship between the law and literature, aesthetics, that is very interesting, also according to the topic of our panel. And he edited several volumes linked to different topics related to legal theory, political philosophy, legal semiotics, law and literature, human rights, and so on. She was also awarded with the habilitation from the National Scientific Committee as associate professor of legal philosophy. Okay, the title of the presentation proposed by Angela is a critique of the distinction between hard and easy cases. As I told before, I remember that the discussions on the papers will be at the end of all presentations. And then we start with Angela. Please, Angela, the floor is yours.
Yes, can you hear me? Okay, thanks, Alessio. Thanks, everybody, for this opportunity. So since the discussion was aimed to be interdisciplinary, because we speak from within the law, but also from various perspectives on law. I chose a topic which is pretty much typical, traditional, we can say, in legal theory, and yet I would say at the same time relevant, hopefully, for so to say, more substantial and law and dogmatic perspectives. And that is to say, the traditional distinction between easy and hard cases. What I will try to do very briefly would be to try and use some of the philosophical theories which Professor Lo Giudice was mentioning earlier about judgment, in order to bring some complexity somehow within the field of judgment in law. How and why? Because basically, usually judgment in law is connected to one specific moment, we can say, to a specific momentum of the life of the law. So if we imagine the different legal operations, the different activities which are related to what we can call the life of the law, which is an expression which is widespread in legal history, we can think of legislation, we can think for sure of adjudication. So at least these two moments constitute the two main structures from which the different operations which relate to the law pertain. Now, if we think of the meaning attributed usually to the term judgment from a perspective internal, we can say, within the law, we would usually relate the term judgment to adjudication. So basically, the tendency, if we don't open up the perspective, and so without using the philosophical tradition, especially on judgment, would be to basically find the correspondence between the very moment of the search for a correspondence between a general norm and the event fact which is being judged. So basically, judgment is what happens also phenomenologically within the court, right? So in somehow like the idea of a last judgment, biblically, the moment where a final word on a controversy is said, is to be found. Actually, as certainly Professor Lo Giudice, or very likely Professor Lo Giudice will have the chance to say afterwards, because he's the real expert on judgment, not me. The term judgment in philosophy is actually being related and connected to also other aspects of human activity in some sense. As a matter of fact, Kant's idea of judgment, for instance, to mention one of the most paradigmatic philosophical traditions on judgment, relates, as he was saying, to taste, to somehow, yes, the act of judging, so in some sense also the act of saying a final word, and yet at the same time to an action which is much more widespread, which is prepared, which happens also before the last judgment, recalling again this biblical image of the final day, the dies irae. Now, so the question basically which I address and which I want to criticize, want to problematize, because it's really like one core issue, since the timing is very short, is where and at what stage are law and judgment interconnected, basically. Given these premises, so given that traditionally within the legal realm, judgment is symbolically connected to the final judgment, the final word on a conflict, and given the other premise that I just mentioned, so that in other traditions, in other discourses, in philosophy especially, judgment is actually an activity which is related to also other operations, operations other than the very final moment of the correspondence between a general proposition and a concrete event. So basically, what we term adjudication. What can we gain from it, from a legal philosophical perspective and from a legal perspective more broadly? Now, as I was saying, one interesting, I think, point of view can be offered by this traditional distinction, this traditional debate between so-called hard cases and easy cases. We can, there are many important authors within the tradition of legal theory have engaged within this distinction. I would mention for sure Herbert Hart. So the father of, well, one of the most, perhaps the most prominent, if we want to make any classifications, a legal thinker of the 20th century. And against him and with him, so in dialogue with him, Ronald Dworkin, criticizing Hart's perspectives, and also, for example, Leo Faller, and also more recently, and you know, a smaller figure within the well, compared to Hart, Andrei Marmor, so a legal positivist, a very important legal philosopher, which can be ascribed within the tradition of analytic legal philosophy. Now, why can we root back this distinction between hard and easy cases to Hart, and so in some sense to legal positivism? Because this distinction basically has to do with the fact that Hart considered the application of rules at the heart of the judicial task, and the very heart, the very core objective of all legal activity. And that basically he had this idea that law has very synthetically an open texture. And so basically every norm somehow must be both determinate and also indeterminate. In some sense, it has to leave an area of so-called penumbra, so shadow, which is indeterminate, so that it can be applied to different situations. So somehow each legal proposition must have both characteristics, must be both determinate and indeterminate. So must have this texture, also materially, which remains a bit open. Now, within this general idea that Hart has, he still distinguishes between cases which, given this open texture of each norm, happen to be easy to resolve, and cases which happen to be hard. This is again a strict simplification, but basically an easy case is a case for which there is one right answer, for which there is agreement on the outcome, a generalized agreement. And hard cases are the cases where there is no one right answer, and there are various possible solutions. So basically cases on which there is more disagreement. Often hard cases are cases, for example, that involve fundamental rights controversies, so controversies on civil rights, on liberties, and so where there is also an hardcore moral disagreement on, or where there can be an important also disagreement on the basic values. Right. Now, so against this distinction, various authors raised their voice, and among which I was naming earlier Dworkin, Faller. So for them, somehow this distinction between cases which are easy and cases which are hard to be resolved falls back within a general mistake of legal formalism, for which somehow the adjudication is a process which happens somehow quite regularly, and for which, when there is an abstract norm which works well, the case can be considered easy. Now, theorists like Dworkin and Faller have strongly criticized this. And a very important critique of this distinction has been also developed by the author I was mentioning before, Andrei Marmor, who wrote an important paper called No Easy Cases. Well, no easy cases question mark, but still no easy cases. So somehow his theory is that since legal language is never about a complete abstraction, and so basically that every generalization, every norm entails a conflict. Somehow he thinks that distinguishing between easy and hard cases is a way of distinguishing too much the process of legislation and interpretation and the final moment of adjudication. So he sees in this distinction, which is, we can say also distinction of school, we would say in Italian, una distinzione di scuola. So it's important to explain to students the difference between these cases, but in the end, Hart was very well aware that somehow that there are no real easy cases. And yet this distinction has been strongly criticized because within a more dynamic idea of the law, which detaches strongly from positivism and strict formalism, interpretation and adjudication and even legislation are seen more circularly as activities which are all interconnected one with each other. And so therefore somehow it is impossible to distinguish. This is the core thesis. It is impossible to distinguish between easy and hard cases because that distinction actually misreads the very idea of the legal proposition. So what is, and now I'm going towards the final and conclusive question and consideration of my presentation. What is Marmor's core idea, and how is that actually interestingly related also to the philosophical tradition on judgment, so that I also, prepared the field hopefully also for the other speeches of this morning. His idea is that that distinction is the result of a misreading of what a legal proposition is. In some sense, in fact, he writes, now I'm quoting, that language is not abstract reflection, and more importantly, that law is not a command, or is not merely a given command, so it's not somehow a fixed rule which stands somewhere, for which some cases can be difficult to resolve and some others are not, but is instead a communicative device, is an intersubjective link, so it works as a language. This is not just Marmor's theory, of course. We have important authors, for instance, like Norberto Bobbio, to stand in Italian theory, which have developed theories on the idea of law as a language, as a meta language, so as a language working on a language. Now, if we consider the law as an interconnected, an intersubjective bond, and as a link, and so basically as a communicative device and not just as a formal or abstract device, then basically all act of designation of a meaning to a term becomes or potentially can be hard. So even the easy case, basically that's the idea, is even the potentially easy case can become hard, and reciprocally even what can be or could have been considered a hard case in reality can end up being easy. So basically this distinction is criticized as a distinction which misreads the very core idea of the law. Now, interestingly enough, Arendt, and this is my final point, Hannah Arendt, who is among the most important interpreters in the 20th century of Kant's theory of judgment, in various works has engaged with the problem of judging. I'm thinking in particular of one work which is Between Past and Future, 6 Exercises in Political Thought, where she actually recalls the the etymology, the semantics of the term lex, and says that lex means an intimate, so she recalls the Latin term lex as something that connects, as something that links together, basically bonds together different parts of a community. And so so starting from this idea, basically she ends up claiming that judgment happens at various stages of human activity. Somehow judgment is the core and basic human activity. And therefore also justice ends up being much more relational than just abstract. And so somehow, according to her reading, according to Marmor's critique of Hart's distinction of hard and easy cases, I would say that in the end, if we really wanted to distinct between hard and easy cases, we could do so definitely not a priori, but a posteriori. So it is a type of distinction that can be made only after things have actually been contextualized and have been considered according to a specific context. And so just the final note, so that this, I think the critique can be closed here. And on a final note, I would recall another important philosopher of the 20th century which engaged on the topic of judgment, which was Paul Ricoeur, who in his theory of judgment, in his work on Le Juste, claimed that judgment is a progressive process, a process which takes place on different levels. So in the end, if we read judgment also through his theory, it would be impossible to see judgment only in the adjudicative moment, so only in that final momentum, but also we should consider the judgment is something which is prepared. So if we apply this idea to the law, we could see that in somehow legal science is judgmental, even and now perhaps even more so in the very moment of the writing of the laws, in the very moment when laws are thought, and also in the very moment of the interpretation of the laws. So I would propose a more dynamic way of reading the distinction between hard and easy cases. And so I would say I will stop here. I think 20 minutes are, I ran out of time also, so.
Yeah, you are perfect. Not only for the content, but also for the time. You are perfectly in time. Thank you very much, Angela. Of course, we decided to postpone discussion and comments after the presentation, but I would like to thank you anyway immediately for all inspiring topics and issues that you put forward. I'm sure that we will deal with a lot of things related to your topic, to your speech during our panel. Now is the turn of Professor Paulo de Sousa Mendes from the University of Lisbon. I'm very happy. I would like to thank you anyway again, Paulo, for his participation. We met last time in Sicily during a wonderful meeting organized by Professor Ruggeri, and I hope really that there will be the chance to meet each other again in the close future. Professor de Sousa Mendes is full professor of criminal law and justice, as well as of legal theory and philosophy at the University of Lisbon. He's vice director of the Centro de Investigação em Direito Penal e Ciência Criminais, vice president of the Instituto de Direito Penal e Ciência Criminais, member of the directory of the Associação Portuguesa de Teoria do Direito, Filosofia do Direito e Filosofia Social, of the Centro de Investigação de Direito Privado, as well as the Consiglio Científico do Centro de Estudios de Direito Penal e Processual Penal Latino-Americano. He has published really widely in the fields of criminal law, justice and procedure, but as well, as I told you before, in the field of legal theory and legal philosophy. And so is the perfect. From my view, representation of the link, of the interconnection of the topics, of the sensibility that are important for our topic. I would like to thank you again, all the participants. I saw that also our colleague, full professor of political philosophy, Fabrizio Sciacca from the University of Catania, is connecting. I'm very happy, and so I would like to welcome him as well. Also, other students are connecting, and so we are going very well. And then I can of course give the floor to Paolo. So the floor is yours, please. Thank you very much.
First of all, I would like to thank you, Alessio, Professor Alessio Lo Giudice, for the invitation. Also, Professor Stefano Ruggieri. It was a pleasure to be with you in Sicily, and I hope to have the pleasure to meet you again in live, perhaps in Lisbon. It is a privilege to speak in this meeting, and a fortune to speak after Angela Condello, because our topics are in some way linked. So it was a good sequence for it. I would like to do my presentation based on a PowerPoint. It would be easier. I have changed a lot the title, Moral Particularism, Justice and Case Law. Perhaps it's more exact for what I have to say. And the summary goes like this: a little introduction, a definition of rational universalism, the failings of rational universalism, the rational particularism as a new paradigm, and an application regarding the case law of European Court of Human Rights. It's just an application and some conclusions. This presentation offers a characterization of rational universalism as the dominant paradigm in contemporary moral philosophy, and then goes on to point out the failings of rational universalism, and hence seeks to demonstrate the need to adopt a rational particularistic perspective as a new paradigm. The discussion of this perspective is important not only for moral philosophy, but also for the general theory of law and for the legal dogmatics itself. We use the term rational universalism to describe a model of practical reasoning which supports the possibility of the rational construction of a system of rules which is valid for all people in all life situations. The main characteristics of rational universalisms are three. First of all, normativism, second, subsumptivism, and third, systemic perfectionism. I'm based on the definition of Maria Cristina Redondo, published in Journal of Moral Philosophy. Normativism suggests that sufficient reason for action in certain circumstances is provided by a norm according to which the current facts become relevant. For the concept of norm as a kind of reason for action, I can recommend Scanlon, What We Owe to Each Other. The norm is general, which means it does not refer to a particular case, but to a set of circumstances, notwithstanding, however, that there may be differing degrees of norms. Norm 1, for instance, is more general than norm 2, when the set of circumstances regulated by norm 1 is greater than the set of circumstances regulated by norm 2. The norm is also invariable, which means it cannot be countered by arguments of exception related to unforeseen circumstances. And finally, the norm is mandatory, which means the justified norm is always the best reason for action, whatever happens. Normativism is usually associated with a substantive, deductive model of practical reasoning. This is the case because the reason for action exists in each case if, and only if, the case is an instance of a relevant universal norm. In this case, the deductive syllogism, or the modus ponens in modern mathematical logic, is a structure which is suited to representing the existence of a reason for action in particular case. Systemic perfectionism is the belief in the possibility of establishing relationships of consistency or priority between all the norms that make up the system. Regarding what I call the failings of rational universalism, I would say that rational universalism reveals serious flaws in the area of practical action and practical judgment, let me put it this way, insofar as it easily falls into formalism. Kant is the representative par excellence of formalism in the field of moral philosophy. I would quote as a good example of this extreme formalism the well-known paper Über ein vermeintes Recht aus Menschenliebe zu lügen. The rational universalism rejects the possibility of abandoning the reason for action or even the reason for judging, even if the due action contradicts our intuition as to what the fairest thing to do would be in that particular case. Aristotle had already opposed the prevalence of universal reason over equity, epieikeia in Greek. Some contemporary philosophers and legal philosophers also term this possibility of abandoning the reason for action and for judgment if it contradicts justice in the particular case, term this possibility as the feasibility of the norm. The word the feasible was used by Hart to define the nature of the norm, which deals with situations which cannot be perfectly universalized, as Angela has pointed in the previous presentation. The law as a word which, with some hesitation, I borrow and extend. This is the word the feasible. This is an ancient paper from Hart in the year 48, 49 of the last century. A very important paper, but it was abandoned by Hart. He never republished it. Even so, it is very discussed in nowadays, and I think that it has strong ideas we can recuperate. It was abandoned by Hart because he in other ways of thought, he developed his legal positivism, and this particular paper is not in accordance with legal positivism, I would say. Some universalists will be willing to yield a little regarding their principle in order to include a certain amount of versatility in their scheme of thinking. Thus, they would say that the norms themselves are not feasible, but they accept the possibility of abandoning the reason for action or for judgment based on the justified norm if the extraordinary circumstances of the particular case mean that the due act is not advisable, as is pointed out by Cristina Rodondo. Well, we have here a dilemma. Norms govern cases or cases govern norms. There is still another difficulty which greatly affects the perspective of rational universalism. The issue is this: the concept of a norm is, in a universalistic structure, implies that the norm must have content which can be identified independently of the individual cases. Norms govern individual cases precisely norms dependent in some way on the individual cases, then the claim that norms govern those cases would be rather strange. Hence, the issue of exceptions to the reason for acting according to the norm based on the extraordinary circumstances raises the more general issue of knowing whether all norms will not, after all, always depend on the circumstances of the individual case. The idea that circumstances of the individual case determine the reason to act or to judge sits well with the so-called situation ethics, defended firstly by Aristotle. Situation ethics is a model of reasons for action based on rational particularism. I took the term from the important book of Jonathan Dempsey, and also the concept, Ethics Without Principles, the provocative title. A particularist will say that uniform and invariably irrelevant circumstances do not exist. On the contrary, the same circumstance may be a reason for action in one particular case, or a reason against action in another, or it may be completely irrelevant in yet a third case. The context of the action explains the different roles that same circumstance may play in practice. A particularistic need not be intuitionistic and absolutely irrational, in some way in the style of Scottish moral philosophy, for instance, rides intuitionism. Believers in particularism may even be rationalists up to the point of accepting the norms as being reasons for action. However, the norms will only serve as place markers or rules of thumb. I quote Joseph Raz, Practical Reason and Norms. Here we may also cite John Stuart Mill, who clearly explained the reasons for using rules, despite stressing that normal people always consider all rules of conduct as being provisional. Having been created for the majority of cases, or for normal cases, rules indicate the least harmful way of acting when we neither have the time or the necessary means to analyze the circumstances of the particular case, or when we cannot trust in our capacity to examine them correctly. Rules serve then as heuristics to save time and reduce the risk of error when deciding what should be done. Why do rules have this heuristic potential? It is because a rule can be examined calmly based on the best available information about the factors which will probably be at play in imagined situations. The rule therefore establishes what should be done in those situations according to a relative weighting of the anticipated reasons. If one of these situations actually occurs, the person for whom the rule is intended may rely on it, thereby saving time and effort, and also reducing the risks associated with errors of judgment, which always exist when the pros and cons of a given situation are considered in a hurry. These reasons determine the nature of rules themselves. Namely, they cease to be useful when we have all the time in the world available to us, or when we can count on the advice of the best experts, and when the use of our time and the time of the experts does not lead to other and undesirable results. These in itself will be reflected in the specification of the conditions for applying the rules. Justified rules only apply when there is a need to take a quick decision or when we are subject to pressure or temptation and so on, depending on the nature of the rule and situation to which they should be applied. It has often been said that these rules are only necessary because of human imperfections. Where there is rationality and full information, there wouldn't be no place for these rules. This is a mistake, notwithstanding the fact that human fallibility is the main reason for having rules. It is not the only the only reason. Discovering the facts and considering the different reasons for action take time and effort, and these are costs that have to be considered, even in situations of infallibility, against marginal benefits which could result from a full assessment of the situation and its merits. These rules are therefore necessary even in ideal situations. Rational particularism may also use a deductive model of practical reasoning. However, a particularistic will only use this model if, within the context of the case, he finds no reasons to derogate from the guiding rule. I will, for finishing my presentation, give an interesting example from this new paradigm, considering the cases bottom up and not top down from the rules and principles of law itself. The case law of the European Court of Human Rights constitutes an inexhaustible body that needs to be roughly known. But the particularism, pragmatism, and informality in the European Court of Human Rights case law, in contrast to the decisions of national courts, provoke a feeling of discomfort and even disillusionment in minds more accustomed to legal constructions based on a dogmatic of strongly rooted principles and norms. We are now obliged to reason from the analogies and differences of the singular cases decided by the European Court of Human Rights. Are we in full transition to a case law model of legal reasoning? It is the open questions I leave for the discussion, because it's a way of thinking based on cases and not firstly on principles and norms. If so, it is in full accordance with moral particularism, I would like to stress. So thank you for your attention, and I wait for the discussion. Thank you a lot.
Thank you, Paolo, very much. I really appreciated your speech, as I appreciated the speech from Angela. And as you mentioned, it's very interesting how many links there are between the two first presentations that we have. I am very ready also to discuss with you a lot of things, even if we will need I think more time than when we have with what we have. And so thank you very much for all issues and your presentation. I will immediately go to myself, I think, because the order is my turn, and so I immediately share the screen. Please let me know if everything is okay. You see everything is okay? Okay, perfect. And I would like to immediately to say that in my view, but it's a question of discussion, my presentation is quite in line, consistent with a lot of approaches that we saw in the first two presentations from both the two presentations. But of course, this is also a topic of discussion, could be just my impression and so on. The title of my presentation, of course, I forgot to introduce myself, even if in the rules of our conference is provided that I have to introduce myself, but I say just that I'm full professor of philosophy of law at the University of Messina. I dealt quite a lot with question of philosophy of institutions and theory of institution, and in the last years I tried to deal with above all the philosophical problem of judgment, of legal judgment. The title of my presentation, is the possibility to imagine a general theory of legal judgment inspired by Arendt's and Kant's remark on discernment. My presentation is meant as an overview, because the topics that I will propose for the presentation are topics that should be dealt with in a very deep way. And so my aim is just to give you the framework of my research, not more than that. And so a very provisional framework. First of all, I would like to stress this idea, the idea of judgment of a mystery. Of a mystery because the faculty of judgment to a certain extent is really different and really mysterious if we compare it with theorizing, deducing, and calculating. Some faculties that we use when we have to decide. But actually judgment is something that is on the top, is what we need in order to apply theory, deduction, and calculation to facts. Considering that in order to apply theory, deductive reasoning, calculating reasoning to facts, we have to be able to connect, as we saw in the previous presentation, rules, norms, principles with facts. And this very hard operation of connection is linked not with theory, deduction, and calculation, but it's linked with the faculty to judge. And so for that reason is a sort of necessary and at the same time mysterious faculty, the faculty of judgment, but it's necessary in order to reason and to argue using other faculties. For that reason, in contrast with thinking above all, judgment deals with concrete realities as they appear to us. And I think that the previous presentations clearly demonstrate this kind of assertion. We have to deal, when we deal with judgment, with the necessity to take a position on a particular case, on a concrete realities, and not with abstractions. Of course, this doesn't mean that there is no link between thinking and judging. They are autonomous faculties, but notwithstanding, they are strictly interconnected. I could say that thinking is something that is able to trigger the faculty of judgment. But judgment, as we will see in few moments, is something really different from the capacity in itself to think. And one of the lectures, one of the lessons, if you want, that we learn from the ancient world, from the ancient thought, as Paolo showed, is just the idea of the judgment as something that has to deal with the particular. Is one of the main theses that, for example, we find in the Aristotelian theory of judgment, as we saw before. But at the end of the day, the problem is, how do I judge? Is a mysterious faculty, and the problem is, how do I judge? And this is a problem not only in the legal field, it's a problem also in aesthetics, in moral, in politics, in society in general. For that reason, the problem of legal judgment is strictly linked to the philosophical question of the human judgment. And if you want, this is one of the reasons why this kind of topic is perfectly consistent in my idea with the general title of the conference of Juris Diversitas, the dark side of law. Judgment is one of the dark side of law that we should deal with in order to understand in a better way the real functioning of the legal phenomenon. As Angela already anticipated, one interesting understanding in a sort of classification of the range of meanings of judging could be found in Paul Ricoeur's proposal. I show you very shortly. Paul Ricoeur say that in a way we can see judging just as an expression of an opinion. And this is a really weak understanding. But judging is also assessing, and so something less weak, something that is related with our capacity to appreciate a behavior or an object. But judging in a more strong way is also the capacity to sharing another strong assertion. And so in this sense, our responsibility is stronger than in the other case. But judging is above all, the proper idea of judging according to Ricoeur, is taking a position, assuming personal responsibility. This is a stronger idea of judgment. It is typical of the legal judgment, when the judge takes a position and he assumes a personal responsibility on the basis of this decision. This is, the notion of judgment that I would like to explore with you, considering legal judgment, because legal judgment is really a way of taking a position on a particular case, always on a particular case. Assuming that, sorry, there is something, okay. Assuming the correspondent responsibility.
Era disattivato l'aula.
Sì. Sorry, maybe we should mute someone. Okay, I think that now is okay. Sorry, I have to come back because, okay, perfect. This kind of practical judgment, the legal judgment, for that reason is far from reducible to the analysis of logical conditions of a propositional scheme, according to which A is B. The legal judgment is not an analytical judgment linked to the capacity to predicate something on an object, or on a behavior. The legal judgment, considering that implies taking a position on a particular case, assuming a personal responsibility, is something more. Is really something more, because it's a practical judgment. And as I told you before, this is a lesson that we learn already from the Aristotelian theory of judgment. And so, which is the question? Which is the philosophical question that we could, underline, starting from this idea of legal judgment? I really, in a schematic way, propose this kind of question. How many facts I need to know in order to judge a human behavior. When do I have to stop cognition and go to decision? Is it possible to reach an objective cognition that leads to an objective judgment? This is my view, the question and the main philosophical question that we have if we start from an idea of legal judgment as a practical judgment, as the necessity to take a position on a particular case, assuming a personal responsibility. For that reason, it's not reducible to a logical operation. For that reason, as I will say at the end of my presentation, it implies a sensibility that cannot be reduced to a procedure, to a scheme, to a specific way of reasoning. I think that one of the best way to understand this nature of the problem, of the question, is taking into consideration one of the most famous understanding about the nature of the error that we find in the metaphysical meditations from Descartes in 1641. When Descartes needs to deal with the problem of the error, he found the nature of this problem in the abyss, I could say, in the distance that there is between intellect, between knowing and will. And actually, this is the distance, the abyss that we find always, as Angela said, not only in the hard cases, but also in the easy cases when we have to deal with a legal judgment, which is the reasoning proposed by Descartes. Whence then come my errors? They come from the sole fact that since the will is much wider in its range, and compass then the understanding, I do not restrain it within the same bounds, but extend it also to things which I do not understand. And so the idea is that there are no limits for the will. I could will everything, but at the opposite, there are limits, there are limitations for my knowing. And so the will is also tempted to go behind the knowing. But when I go further, when I go further in comparison with the limits of my knowing, then there is the risk or the certainty of the error, of the mistake. And we find in Descartes, and as the will is of itself indifferent to this, it easily falls into error and sin, and chooses the evil for the good or the false for the true. And so it's really the problem of the abyss, of the distance between intellect and will, the problem that we find in judgment. And as I told you before, is the problem that we find when we have to understand where to stop our cognition in order to go to the decision. You all know, Paolo mentioned the question of the deductive reasoning, that the syllogism was the main way used by legal practice and legal science in order to deal with this problem. But at the end of the day, in the hard cases, but if we follow, as I follow the understanding from Angela, in all cases, there is always a problem with the syllogistic reasoning. It's always a reasoning a posteriori. It's always a reasoning that idents, I would say, a substantive evaluation. Because as we all know, there are a lot of questions that should be dealt with, building the minor premise, the fact, and building the major premise, the norm. In both cases, we have to deal with the evaluative reasoning that are not reducible to a syllogistic reasoning. And so the syllogism, as a lot of literature confirmed, is not able to solve the problem of the abyss, but is not able for one reason, in my view, because the problem of the abyss is at the same time the nature of the judgment. The abyss between intellect and will is not a problem that we could solve in a definitive way in the judgment, and above all in the legal judgment. Is a question that is related with the nature of the judgment, and so we have to deal with that. We have to manage this question in order to deal with the question of judgment. In my view, one of the best attempts, not definitive, to deal with this kind of understanding is possible to find in Hannah Arendt's Insight on Judgment. Insight, because as we all know, there is no a systematic theory of judgment in Hannah Arendt, even if she intended to deal with this big topic in the third part of the Life of the Mind, the book that was not finished because Hannah Arendt died before. But in several books, above all articles, and I would say above all in the lectures that she gave on Kant political philosophy, we could find an insight that could be useful in order to understand a route that we could follow in order to deal with the abyss, with the question of the judgment, of the practical judgment, of the legal judgment, in my view in particular. Hannah Arendt said, inspired, as I will show you in a few minutes, inspired by the critique of judgment of Kant, wrote that there are two mental operations in every judgment. There is the operation of the imagination, in which one judges objects that are no longer present, that are removed from immediate sense perception, and therefore no longer affect one directly. And yet, though the object is removed from one's outward senses, it now becomes an object for one's inner sense. This is very interesting because it's a good description, in my view, of the dynamic of legal reasoning. We have always to deal with an object, with a behavior, with a fact that is not longer present. We have always to use our imagination in order to deal with a case, because the object is removed from our immediate sense. And so we have to oblige to work with our inner sense, with our inner sensibility to judge practical case. This operation of imagination prepare the object for the operation of reflections. And this second operation, the operation of reflection, is the actual activity of judging something, according to Hannah Arendt. This twofold operation establishes the most important condition for all judgments, the condition of impartiality, of disinterested delight. The imagination is a way to take distance from what we have to judge. And when we take distance from what we have to judge, then we have to reflect on ourselves, on the situation imagined, represented, and then we could have the chance to have a judgment from an impartial position. I mean, this approach is strongly linked with Kant critique of judgment that we find, of course, sorry, I had a mistake. Okay, that we find in his masterpiece. I have no time here to deal with all complex questions related to the context of this important work of Kant. You all know that actually the topic of Kant was the taste, was the aesthetic, but it's very interesting because in my view, this could be a topic of discussion after the presentation. In the critique of judgment, there is a sort of abandon of the formalism used by Kant usually in dealing with judgment, because according to his understanding of the problem of judgment related to aesthetic, to the taste, we could say that for Kant, in that case, there is no chance to deal with universal rules. There is not this possibility. It's necessary actually to deal considering that there is not a universal rule. There is not the universal rule of beauty. And then we have to find the principle of beauty in the particular object. Maybe of course, I skipped one important point very briefly. For that reason, in the critique of judgment, we find an important distinction, a distinction between the determinant judgment, that is the classical judgment, the judgment linked to the capacity to subsume a particular case within a general norm, and on the other hand, the idea of the reflective judgment. If, wrote Kant, on the contrary, only the particular is given, then the faculty of judgment must first of all find the universal for that particular instance, must find the universal concept made possible by that particular instance. I mean, my idea, according to all framework that I try to show you, is that in the legal field, notwithstanding the appearance, the kind of judgment useful in order to understand the nature of the judgment is the reflective judgment. Because as Angela and Paolo showed in a very, very good way, we have always to deal with the case, with a particular case. We have always the possibility to deal with the general norm, but actually the case is always able to make possible the understanding of the norm, the understanding of the general principle, the concretization of the general principle. Finally, according to Kant, in a very short way, there are three maxims of sensus communis, the three maxims that we can derive from the right intellect, from the right way to reason, that we can use in order to deal with particular case when we are not able to have at disposal general rules. And so these are the three maxims: to think for oneself, and so without prejudice; the maxim of the judgment, to think in the position of everyone; the maxim of the broad, of the larger-minded; and always to think in accord with oneself, the maxim of the right way of thinking, the consistent way of thinking. I mean, my idea is that, but it's just a sketched idea, that from these maxims, we could understand, we could derive some guidelines that could be useful in order to deal with the legal reasoning, a legal judgment, sorry, that is always a judgment based on the urgency of the fact, on the prominence, on the primacy of the fact, without a static, invariable, general rule able to allow us of such. And so we could derive, for example, the necessity to be free from idiosyncrasies and prejudicial point of view. We could find, above all, the necessity to take into consideration different points of view without losing autonomy, mentally simulating to be apart. And we could find the necessity to following a consistent argumentation without logical contradiction in order to sustain the decision. These are actually some maxims that could derive from the practice of the judgment, from the practice of the judgment that has to deal with particular case. Of course, we could also find some references to these guidelines in some positive norms that we have in our legal orders. But in my view, this kind of maxims, also the legal maxim of sensus communis, are linked above all with a sensibility and not with a procedure. Because at the end of the day, and I am at the conclusion of my work, of my presentation, the structural ambition of legal judgment is justice. But through legal judgment, the human particularity has to be judged without the support of a universal concept of justice. There is an analogy between the aesthetic field and legal field. We have not a universal concept of beauty. We have not a universal concept of justice. This is the ineluctable challenge of the legal judgment. Maybe the awareness of this abyss of the judgment is a good way to deal with such challenge. And so coming back to the title of my presentation, it's quite important to understand if we could deal with a generality of legal judgment or with a philosophy of legal judgment. Considering that, in my view, judgment is above all a matter of sensibility and not a matter of procedure, I think that the most promising route is the route that leads us to deal with a philosophy of legal judgment. And maybe we have to abandon the ambition to reach a really general theory of legal judgment. Thank you very much. I can stop here my presentation perfectly. Okay, now I think that we could immediately go to Stefano Ruggeri, our friend and colleague. Stefano is Dr. Juris at Sant'Anna School of Advanced Studies in Pisa, and currently, above all, is full professor at the Law Department of Messina University, holding the chair of Criminal Justice and teaching Criminal Procedure Law, European and Transnational Criminal Justice, and Evidence Law. Is member of several editorial and advisory boards in national and international journal in the field of criminal law and criminal justice. He's also editor-in-chief of the book series Legal Studies in International, Comparative and European Criminal Law. And he was awarded of a Humboldt Fellowship for experience in research, carry out his research at the Max Planck Institute of Foreign International Criminal Law in Freiburg. His main research areas encompass inter alia generality of law, evidence law, transnational criminal justice, comparative criminal law, and European criminal justice. The title of Stefano's presentation is Fact-Finding and Adjudication in Criminal Trials, Reconstruction, Transfiguration, and Projection of Human Behavior, with interrogative point. Please, Stefano, the floor is yours.
Thank you so much. First of all, to my dear colleague and friend, Alessio Lo Giudice, and for his kind words and invitation. And also, I feel really honored for being here, for having had the chance, the opportunity for hearing so beautiful presentations and learning so deep concepts. Due to the time, I will just focus on try to summarize the subject of my presentation and just raise some questions open today to the discussion. It is wide opinion that criminal trials deal with facts, but this fact-finding adjudication seems to be a rather vague, a rather unclear relationship. What is fact-finding? What is adjudication? Shall facts be found or adjudicated? And can we conceive of facts outside process, outside our procedural experience? Let's say so, these facts are able to lead to the imposition, enforcement of a punishment. And what is adjudication? Do we consider only judicial adjudication, so by a judge or court, or do we have to broaden our viewpoint and extend it also to other forms of adjudication by bodies other than judges and courts? And above all, does adjudication have only to do with facts? So the traditional way of dealing with these questions in criminal justice is to follow a sort of legal chain, a legal sequence. And the sequence is very simple: law, facts, process, adjudication, and punishment. Legal scholarship has pointed out in very clear terms that the process stands in the middle between the crime and the punishment. And our two first codes of criminal procedure in Italy after the unification said in very clear terms that the crime generates prosecution. Prosecution is born by the crime. The crime is a sort of presupposition of criminal trial. Now, a critical reflection on these points shows several weak aspects of this approach, and also some dark sides of our criminal justice, or the developments of criminal justice in several jurisdictions. As my colleagues have pointed out previously, the utopia of a well-defined law, even in the flexible concept of Strasbourg case law, which is satisfied with not written law, provided, however, that it fits the need for accessibility and foreseeability, a predefined entity. But this idea, this utopia, has long been called into question. As Angela has said before, law is a communicative device, as a progressive communication. And this especially applies to criminal law, due to the enormous expansion of criminal legislation and the introduction, and this criminal law scholarship has pointed out this phenomenon in my country over the last decades, the introduction of criminal law provisions whose essential elements are largely undefined or partially undefined, or they cannot be established in exact and clear terms in advance. For example, conduct of criminal participation or accomplishment, or organized crimes especially. Of course, this result strengthens the role of criminal decision making, but also alters the terms of our legal sequence with the following implications. First, as Jacobiello had pointed out, the criminal trial does not only adjudicate well-defined facts on the basis of a well-defined law, but also aims at adjudicating the law itself. Second, the standards and above all the limits of criminal law relevance in more and more defined ex post, that is, during the trial and by means of the trial. The facts are often defined by the available evidence, that is, on the basis of what can be proven. So in the light of this, the original legal sequence may often be reformulated and returned. So we don't have to prove facts as pre-established entities, but evidence or evidentiary processes just jump over this, prove to the facts, and contribute to redefining criminal law hypothesis, but this means redefining the law itself. Sorry, Mike. The increasing expansion of criminal law does not only lead to the overlapping of criminal law provisions and the increasing interaction of criminal offenses, but also interferes with the traditional relationship between substantive and procedural criminal law. This phenomenon, this result can be observed, I think, in two main ways, or in two main fields. The first one concerns the choice of nomen juris, so the legal classification by the competent authority to charge, according to relevant jurisdiction, might be a prosecutor, public prosecutor, investigating magistrate, etc. The main problem arises when nomen juris is chosen not the basis of a clear law, but for procedural reasons, for procedural strategies, for acceding measures of investigation or pretrial measures which are allowed only for certain crimes, or are subject to special facilitated rule for certain crimes, for example, pretrial detention for organized or terrorist-related crimes. The second innovation, the second phenomenon, the second field of observation has to do with the old bracket Jura Novit Curia, and pertains to the possible alterations or modification of the factual basis through modifications in Europe, so of the legal part of the charge. Sometimes the decision makers, the competent judge or court modifies only the legal classification, but in this way, some factual modifications take place in a hidden form. An instigator that becomes an actual perpetrator, an accomplice who becomes a secondary participant. From this phenomenon, we can draw the following conclusions. The first one is the adjudication does not only concern the issue of verdict or guilt of innocence, what Germans call the Hauptsache, the merit, the main decision, but also interim decisions, prosecutorial decision to charge with a certain nomen juris, the decision on the application of pretrial measures or certain measures of investigation. The second implication has also to do with an old Latin brocket, dami factum dabo tibi jus. You give me the fact and I'll give you the law. But this brocket does not truly reflect the real dynamics of criminal proceedings nowadays. In particular, when the prosecuting authority is a representative of the judiciary. In Italy, public prosecutors are also representative of the judiciary. The decision to charge does not only provide a factual, but also a legal basis of the future decision. And neither can it be said that judicial adjudication regards only the law for decision making and often been about to bring about significant changes of the factual basis. Carneluti, one of the main scholars of our tradition in Italy, said that adjudication is also a progressive process. It's a process itself and does not take place at the end of evidence gathering, but characterizes, cuts across all the exercise of judicial power itself. More deeply, we can also link perhaps the developments in criminal justice with what Alessio said before. That is, there is this widespread opinion that criminal trials have to do with facts, so with objective facts. But this is not true. This is not true. A criminal inquiry can, up to a certain point, be activated, be initiated, be conducted without identifying specific individuals, but up to a certain point. But the decision to charge and the decision on guilt or innocence presupposes a specific subjective direction. The criminal trial and the adjudication within the criminal trial does not mainly relate to the facts, to objective facts, but to hypothesis of facts with a potential criminal law relevance as committed or attempted by specific individuals. That is, specific individual conducts. The criminal trial, the criminal process deals with hypothesis of the past, and aims at orienting a human behavior in the future. As Carneluti said, Professor Le Giudice recalled in a recent wonderful essay, a superhuman task, ascertaining the past to orient a future human behavior. Think about, for example, criminal trials conducted against minor offenses. Notwithstanding this natural projection, let's say even vocation of criminal process, specifically directed through towards individual conducts, most prosecutorial even judicial decisions in the pretrial inquiry, specifically in the pretrial inquiry, only deal with objective facts, with a partial vision of the crime. Although they lead to the adoption of measures which severely interfere with individual rights, fundamental rights of the person investigated, and even of third parties or non-parties. And this is also a phenomenon which can be observed in the Hauptsache. The spread, the worldwide spread of special procedures, bargaining procedure, plea guilty, abbreviated procedure, also entails that judicial assessment is often weakened as regards subjective elements of the alleged offense, for example, mens rea. Now, we have to think in general terms that the specific feature of the criminal trial does not allow to think about prosecution and adjudication in terms of res in judicium deducta and adjudication of facts in real term, because, and this leads to the initial question, there is no res, there is no fact that we can legally appreciate, we can legally observe outside and prior to the process. Far from finding facts, the criminal process aims at ascertaining legal facts, and ascertainment is functionally linked to legal certainty for the protection of the individual who has undergone, who has suffered from a criminal proceeding. A criminal trial therefore deals with factual and legal hypotheses in order to produce the specific, the real rule of conduct for the person concerned and the society in general. And in sum, adjudication in a criminal trial materializes the criminal law provision and therefore produces criminal law in relation to specific case. In a book of almost 1 century ago, Professor Cariluti said that, as paradoxical as it might appear, it is not the process which presupposes the crime, but it's the crime which presupposes the process. And right to the conclusion. Despite this undoubtedly creative nature of judicial adjudication in criminal proceedings, res judicata does not hold constitutive, but also barrier effects, because of the main goal of protecting people in the criminal trial.
Sure.
Most interestingly, from the viewpoint of the present discussion, I think the res judicata, the most interesting thing of res judicata in criminal matters is that it does not only cover what has been adjudicated. We might even paradoxically say that res judicata is partially uncoupled, is unrelated from both fact-finding and adjudicating. Ne bis in idem, as Strasbourg jurisprudence has shown, is not linked to legal classification. For example, as shown in the Grand Chamber case of Zolotokine. Ne bis in idem also, and most interestingly, goes behind the sole facts adjudicated and sometimes cover even facts which could not be adjudicated for the simple fact that they materialized after and not before the criminal trial had been finally completed. In exceptional cases, the criminal trial, no matter whether it is concluded with an acquittal or a conviction, turns out to cover future behavior of the defendant on the basis of the adjudication of future and not past facts. You adjudicate a person for strong or severe injury and for having been stand, and you cannot adjudicate the same person for murder. But in cases of acquittal specifically, the criminal trials also satisfy the goal of ascertaining legal facts and producing criminal law in the specific case on the basis of partial, uncompleted, and even hypothetical fact-finding. That is, the criminal hypothesis at the end remains a criminal hypothesis, an hypothesis of a criminal conduct. But notwithstanding, the criminal trial satisfies its goal of ascertainment. And thus, this is perhaps the mystery, I think, to just recall what Alessio said before, of res judicata in criminal matters, which covers the gap between fact and law, and does not only aim at orienting future behavior, but also protecting people in the future from jus terribile, which is the old and never forgotten idea of criminal law. So I think I had talked too much, as always, sorry, and thank you so much for your patience and for your attention.
Thank you very much. Thank you very much, Stefano. Stefano, I think it was a perfect final speech for our panel, and I'm very, I mean, not astonished because I was prepared to that, but really the link, the interconnection. If you want, also the consistency, theoretically speaking, of our speech, in my view, is quite strong, it's quite interesting. But I don't want to use time for discussion. Adding other words, and so we have for sure 10 minutes at least of discussions. And so for discussion, so the floor is open for everybody, for speakers, for participants. I just asked to propose very short questions in the way that we can deal with some of them in our time. Please, there are some. Are there some questions? Consideration, comments, everything, of course, not just question in a strict sense. I saw that.
Maybe I just intervene because I don't know whether you see me.
We see you.
If I might, I'd like to congratulate all the speakers. It was very highly interesting and inspiring. I would like to ask questions. Basically, they probably relate to all of you, even though I'm picking, of course, I'm picking one thought that I thought was very interesting in Alessio's presentation, and I'm wondering how it might relate to the others. So it's basically a question addressed to all the speakers. I'd like to take up the idea that judging involves and engages to some extent the responsibility of the person that is judging. I find that a highly interesting idea that I haven't thought of personally, at least not to a large extent. And I'm wondering, maybe first in relation to Angela's presentation and the conclusions, if I understood correctly, I think, right, an interesting observation that judging is basically omnipresent in the activity of the lawyers. And I think once you say that, you open the door, of course, to the next argument, to looking for subcategories of different types of judging. And here, I mean, my question, would the idea of responsibility of the person judging be an element that could be taken into account when looking at the responsibility? This similar concept of responsibility applied to Paolo's presentation, and more particularly the critique of the case law. I found that very interesting. Paolo, your observation on the case law of the European Court of Human Rights and how particular and not general it was. And the question here, again with the same concept, do you think the idea of the responsibility as the judges perceive it might play a role? So these specifically addressed to the two of you. And then finally to Stefano, I think in your very pertinent observation, I especially enjoyed your insistence on the difficulty to distinguish between facts and law. And here again, I think the idea of the responsibility might be an interesting consideration. So I would be interested to hear you develop on that topic.
Thank you very much. I think Angela, thank you, Lucas. Really, could you reply?
Yeah, I would say, yeah, thanks for the question. It's very, I mean, it makes me think even further. I would say that the main answer is yes. Responsibility is somehow this kind of subjective responsibility is involved if we understand the law as this kind of social bond, this system of rules which create links, which of course is made by men. So obviously there is responsibility at stake also in the choice of, for example, in calling a civil union wedding or civil union, for instance. Think of same-sex marriage. Well, not wedding, sorry, marriage. I was thinking of unione or matrimonio. And so also the choice of the terms. And then, of course, the meaning you attribute to the terms. Somehow, if you take a general late Wittgensteinian account on language, clearly some amount of responsibility is involved at all stages. Obviously, when it's about death penalty, abortion, in the Constitutional Court decision, it is somehow the theater at stake, the number of people involved and looking at the scene is larger. So there is more echo in some sense. But I would say that theoretically, even the tiny issues entail judgment in the sense that we understood it. It's like that physical issue when, I don't remember the English term, I even don't remember the Italian term, but basically when a minor event occurring in, I don't know, Heidelberg for a series of attached events then provokes a consequence somewhere in San Diego 10 years later. So there is some kind of, I would call it an eco effect of this responsibility, which of course entails that, yes, responsibility is at stake, also also at other levels, or levels other than the pure adjudication. If there is a pure adjudication, that's the thing that Ricoeur and Arendt suggest. Is there a pure adjudication? Is there something as such, especially in a discourse like law, which is made by men? So it is artificial and fictional in itself. And so even the very creation of this social object entails an engagement and entails that kind of jump in the void that Alessio was describing between different human dimensions, will and knowledge and so on and so forth. So yes, I want to leave the floor to the others. Sorry, long answer.
Thank you, Angela. Paolo, if you want to comment, reply, or whatever.
Okay, thank you for the question from Lucas Urscheller. Well, on the case law, I think that European Court of Human Rights is changing the way continental scholars, European scholars are thinking about the methodology of adjudication. For instance, when they decide the cases, if they are in accordance with a fair trial principle or not. European Court of Human Rights looks always for the case as a whole, not regarding especially a default or a failure in procedure, but if the process as a whole was or not fair. Well, that has to do with the fact that European Court of Human Rights does not really adjudicate and has to deal with the law from different 47 states, but it has an important role in the way we think. If we look for a case to adjudicate it as if it was fair as a whole, we are deciding the case, not deciding it in abstract terms regarding firstly for the principles or for the norms in internal law or even in the European Convention of Human Rights. And at the same time, we look for the case law of European Court of Human Rights, not only for the opinion of the majority of the judges, but also for the dissident opinions. Let me put it like Oliver Wendell Holmes Jr. The dissident opinion from today can be the future of the adjudication and the interpretation. So at the beginning, we have the case, not the law, not the norm, not the principle. And we can adapt it even to our own countries. Let me put it like Stefano spoke about it. At the beginning, we have the procedure, not a crime as violation of criminal code. At beginning, we have a notitia criminis. And when we ascribe responsibility, we call someone to answer in court, to put it like Anthony Duff. That's the main goal of ascribing responsibility or rights, like in the seminal work of Herbert Hart I spoke about. And I'm in total agreement with Angela when she said that it is not the case itself that is hard or easy. It depends on the judgment, and that has also a procedural dimension and an evidentiary dimension. Some cases can be easy regarding the same subject, and others can be hard. It depends on the judgment itself and on the progressive process of adjudication. And let me end with a question for Alessio. I was very interested about when he took Kant as a basis of his own reasoning, and he proposed a way of abandoning the formalism of Kant, saying that there is not the universal law of beauty, as there is not the universal law of judgment. I think that we can take some parts of Kantian thoughts to adapt to the legal field, that and to use it as maxims of sensus communis. But it's not an easy way to deal with Kant. I remember, just as a provocative quotation, even Eichmann invoked Kant and the mandatory imperative to say that he acted as he had to do it because he was always thinking on the Führer's principle. The will of the Führer was the main goal of his own action. So we can use, of course, Kant in many ways. Would you explain how would it be possible to use Kant himself to abandon the formalism of Kant in the legal field, this faculty of judgment as a way of using the case as the basis for the ascription and not the principle, not the universal principle, not the norm, not the universal norm. So it is one question. The second is my doubts about the process of adjudication. It has to do with knowledge or not. Sometimes I think that it has only to do with proof, and proof is not knowledge. So it cannot be a case of error, but a matter of authoritative opinion. And quoting also in a very provocative way, Scalia, mere factual innocence is no reason not to carry out a death sentence properly reached. So a judgment is a good judgment when it is properly reached, and we cannot appeal no more, not even for the European Court of Human Rights. In a provocative way, we can say that it has not to do with knowledge, and it's not a possible case of error, but a matter of opinion, well grounded on proofs and in adversarial and fair proceedings. So it's my comments. Thank you a lot. And
Thank you, Paolo. I asked Lucas because actually, basically speaking, we had our time for discussion, but I would like to ask you, we have the chance to continue or not? But I would like to respect, of course, our rules, and so I would like to ask you, because I said to the other participant, Lucas is not only our colleague, but also a member of the executive board of Juris Diversitas. It was a wonderful host of, at least for me, two world conference of Juris Diversitas that were held in Lausanne some years ago. And so, Lucas, I don't know, we can use other minutes for discussion or not? What do you think?
Absolutely. No, I don't see any reason why we should limit ourselves in time. People might leave, of course, but I think the people who are interested, as long as they stay, we stay, no?
Okay, thank you. And so I think that I could give the floor to Stefano if you would like to comment the consideration that we had from Lucas, and then I will say something about what Lucas said, also Paolo. Please, Stefano.
Thank you so much. It is not an easy task for me to answer these questions because I don't have a yes or no answer. I'm truly concerned about this process of adjudication and interim adjudications, because criminal law aims at punishing the perpetrator, so those people who committed the alleged crime. But criminal trial has a punitive potential which goes far behind this, because criminal procedure, criminal investigations, means of investigation can interfere, can impinge upon fundamental rights, not only of the perpetrator, but also upon individual rights of a wide and sometimes undefined number of people. And this enforces, strengthens, dramatizes, let's say so, the question of responsibility, but responsibility of partial decision making, because we always think of this adjudication in a public trial by a court, that sometimes you have to take a quick decision, and this decision will immediately be enforced, will have tremendous implications on the right to free circulation, the right to liberty, the right to free communication of people. So the rule, which the procedure rule of several courts will say that pre-trial orders do not have suspensive effects, is not a procedural rule of conduct. It reveals this tremendous potential of interim adjudication. And what I see in my country and in other jurisdictions, also European jurisdiction, I know, but perhaps my impression can be wrong, hopefully will be wrong, is that this provision we somehow overlook, we somehow or underestimate this provisional adjudication. But this provisional forms of adjudication are mainly based on an appearance of a crime, what Spanish colleagues defined apariencia delictiva, so a fumus delicti, which was a partial view of the crime. German scholarship used a category some decades ago, Sachgestaltungsvoraussetzungen, so requirements of manifestation of the crime, as a sort of a part of the moon. And this partial adjudication, paradoxically, we have a partial, uncompleted, vague sometimes, fact-finding, which has tremendous implication on human rights. And who is responsible for that? Sometimes law enforcement authorities, sometimes the police, sometimes the judge, the pre-trial judge or investigating magistrate. In recent discussions in my country or in other European jurisdictions, but perhaps Paolo may not share this opinion, I don't know, is we talk with the main discussion is about who is competent for what, whether the prosecutor, a specific competence should lie in the hands of a public prosecutor or in the lie of a judge, guarantor, a judge competent for guaranteeing fundamental rights. But the question is not only the distribution of competences, it's how to deal with adjudication. For example, in Italy, wiretapping or nowadays cyber investigations on the basis of Trojan horses must, as a rule, must be ordered by a judge. But this judge has the old mythological polyphemo, has only one eye, a big eye. And this eye is the eye of what the public prosecutor produces, or the elements of the information that the public prosecutor produces to this judge. So the proportionality, the necessity, the fumus delicti, the apparentia of the crime, all these fundamental requirements are adjudicated on the basis of a partial, by definition, partial view. Is that a good deal, way of dealing with a good approach? I don't think so, but it's only my opinion, of course. Oh, sorry, I talked too much. Again.
Thank you very much, Stefano. Thank you very much, really. There is because before to add other replies, I noticed that there is a request for a question from Costanza Pizzo. That is she's a law student from the University of Messina. Please, Costanza, the floor is yours.
Okay, thank you, and hello everyone. First of all, I want to say I really appreciated this webinar and thank the speakers and the organizers for making it so interesting. And my question refers to responsibility of the judge, so the need to decide the case. And perhaps I think it would be better to say, to use expression, finding the legal truth. instead of deciding the case. Of course, bordered within the possibilities of the prosecutor and the judge himself. It is clear that the procedural dimension is a protection that is granted to the prosecuted, but sometimes I feel like it appears to be fumos, to use Professor Ruggeri's word, as it doesn't grant the general perspective that Kant called sensus communis, which we talked about. And I wonder, how does natural causality enter the picture in the practical matter in this case? Thank you.
Thank you, Costanza. I think that even Costanza question is a question related to all topics at the end. I don't know if are there other questions in this moment, or we continue with some replies. Okay. In the meanwhile, some other question could come. I would like just to say something very briefly about the interest question. Put forward by Lucas about responsibility, and in the questions, in the answer, sorry, we found the different aspects that this kind of responsibility could imply. Far from a technical idea of responsibility, because as you know, for example, in Italy, in this moment, there is a big public debate about the technical, in terms of legal responsibility that the judge should have for the decision, above all for the mistakes that they could do. And so this is also an important kind of responsibility. But in my view, when I put forward this basic idea of the legal judgment as taking a position on a particular case, assuming personal responsibility, I was a lot inspired from the Kantian idea of reflective judgment, in the sense that if you have to find the rule, you have to find the norm, the principle from the case, in the case, then it means that you have to reflect on yourself. You have to reflect on your ethical consciousness. You have to reflect on your ability, as Kant says, to think, simulating to be one of the parts, simulating to be one of the actors. And this means to take a existential, I could say, responsibility. And it means to put forward your sensibility that is not just legal, but is above all existential. And so, as Nancy said, Angela translated into English one very interesting essay from Jean-Luc Nancy, Dies Irae, on this topic. As Nancy said, actually, when you judge, you are always judged from the judgment. And this is the idea of responsibility that I think about. Just a word, but not because it's sufficient a word. Actually, Paolo, we should deal an entire week to deal together with the topic that you put forward. And in my view, there are also a lot of interesting points, and I will mention that in your topic. But about your question, of course, as you know, I'm very maybe too much influenced in my reading of Kant from Arendt reading of Kant. And I know that the Arendt reading of Kant is not considered from the Kantist specialist, is not considered always orthodoxian, reading. Maybe for some authors is a little bit heretical. Maybe this is the reason why it's interesting for me, because the heretical reading of Arendt make possible to use in a very interesting way some insight, inspiration that we could derive from Kant, even if they are not so consistent with all the Kantian apparatus. But strictly speaking, what I share with the Arendt reading of Kant is the idea of the anomaly, if you want, of the critic of judgment in comparison with the critical of pluralism of practical reason. In my view, Arendt is right when she said that is not so consistent, the critic of judgment, with the previous critics, or at least is a way to deal with a problem that is the problem of the abyss, of the gap between intellect and freedom that Kant found in the previous criticism. For that reason, in the critic of judgment, we find something that is not Kantian, I would say. I mean, he said explicitly that you cannot deal with the judgment in the aesthetic field thinking that you can use a sort of a priori principle in order to judge the case. And this is really not Kantian. This is against what Kant wrote in the previous critics. But the most interesting point is that at the end of the day, Kant said that the aesthetical field is a paradigm for every judgment, every practical judgment on the human behavior. And so for that reason, in my view, is not promising, because I could not say that it's promising something that Kant wrote, but it's really, really interesting also in this heretical reading, starting from his way of dealing with the problem of the aesthetical judgment in order to deal with the legal judgment. Because at the end, which is the problem for Kant? The problem is that if we see at the experience, if we look at the experience of the aesthetical judgment, we find something very strange. Because when you express aesthetical judgment, you know that your judgment is subjective, is based on your subjective feeling, but at the same time, you pretend you have the ambition to be understood from everyone. You have the ambition that your declaration of beauty could be universally communicable, universally shareable. And this is the strange point, because you have the ambition to the universality, but you know that the ground of your judgment is a practical subjectivity. And according to Kant, what happens in the aesthetical judgment is that we are inclined to take distance from the object. Because the first reaction to an object, an artistic object, for example, is to say, I like, I dislike.
Sure.
But this is not an aesthetical judgment. The aesthetical judgment is when you can say, is this beautiful or not? And in order to say that it's beautiful, you need to take distance from the object. You need to reflect on yourself. You need to think about the possible judgment of all other person. And after this operation, and so you are forced to simulate to be another person, to think as with the mind of other person. After this representative operation, and so the working of imagination, then you can come back and to explicitity of judgment. Of course, it's always a subjective judgment, but with this operation of reflection, imagination, taking distance from the object, you could have the ambition to judge in a way that could be rational, understandable, and also shareable from other persons. My idea is that this is a very promising model for the legal judgment. if we start from the idea that, as you mentioned before, that the case is the beginning, and then from the case we could have the possibility to find the chance to judge with the aim of justice, with the ambition to justice, even if we know that we don't have, and we never had, as Kelsen said, was right there, we can never have a universal concept of justice. And so this is, and so I totally share your reasoning and your proposal of reasoning. The interesting point is try to see if we could really understand in a sort of heretical sense the critique of judgment, but without forcing the interpretation. My idea is that really Kant take distance from something that previously wrote on that. And I take the chance just to say 3 really short words on the presentations that I heard. I think that among several things, it's very interesting the main thesis that Angela put forward. And I think, but we will discuss on that, we will have time for that. I think that your thesis is able also to challenge art understanding, because I mean that in my view, within Herbert art theory, we find the possibility to dismantle the distinction between easy cases and hard cases. Because art himself said that the legal language is always underdeterminate, is vague. And so this means that even in the so-called easy cases, there is the space of what he called the integration of the scope of the norm. And so very, very, very interesting. A word, but I mean, on Paul, I would like to say a lot of things. I think I really, really appreciate, and I would like to have several chances to deal with that with you. The point in which you explain that following rational particularism doesn't mean to follow an idea of intuitionism or irrationalism. I think that is a route important to follow, because Paolo, as you know, usually when you put forward thesis like the thesis that we are sharing, the main objection is that, okay, you are an intuitionist. Then you are going towards the discretion, the arbitrariness, the irrational way of thinking about law and judging. And I think that is totally a mistake. And I mean, your idea, your way of approaching show perfectly the way in which rational particularism has nothing to do, if really understood, with irrationalism or legal creationism, I would say, that usually. And afterwards, I had a lot of talk with Stefano about a lot of these kind of things. But I think that when he said that the adjudication is not just on the fact, but is also, or maybe above all, on the norm, I think that is one of the core of the symbol of our panel is a sentence, because it's a way to put forward a strong connection among all our understanding that lead to see how dynamic is the process, as Stefano put forward several times, the process of judgment that could not be reduced to the final decision. One word, because I had, of course, also Costanza. I like really your question, and it's very interesting when you said, Costanza, that the problem of the responsibility is also linked, if I understood, to the traditional ambition to the truth. I mean, the idea that at the end of the trial, there should be the chance to ascertain the truth, and so the truth of the facts, the truth of the conducts. This is a sort of burden, I could say, that create a strong responsibility that is also linked with what you said, the causality, I mean, the link of causality that you have to find in the assertment of the facts. But my idea is that responsibility has to deal not with the truth, but has to deal with the personal involvement of the judgment of the judge in the judgment. For that reason, at the end of the day, is above all a matter of sensibility, in my idea, the judgment. Sorry for the time that I take. Are there other questions? Also, other replies to Costanza question or not? Thank you, Costanza. Okay, Costanza had the answers. Okay, I think we are 30 minutes, basically speaking, after our plan, but I am sure that we will have to speak, to chat, to deal with these topics really more and more. And so, but anyway, I think it's also right. Lucas, what do you think? I think it's also right to, if there are no other questions, to end here the panel.
Absolutely. Thanks everyone. I personally have to leave for homekeeping duties.
Yeah,
so,
of course.
But thanks, and I really hope that we can continue the discussion in some form. And congratulations to all of you for putting together the panel and for your very interesting thoughts.
Thank you, Lucas, and I would like to thank you all the participants, Angela, Paolo, Stefano, for really their inspiring speech, comments, consideration. My idea, but we will have time to deal with that, is that maybe it would be wise to think about the chance to write something together, to think about a collective work on these topics, maybe also involving other scholars, of course. But I mean that actually is the second time that we deal together with topics like this, and so I think that now we are ready also to write something together. But I mean, we will deal with that. Thank you again. Thank you also to all the participants, all the students, colleagues, and so on.
Thank you all, and I will be pleased to write something together with you. Thank you.
Paolo, just a moment. I don't know if you see that among the students connected, there is also Francesca Di Pietro, that you know very well because she was with you at your university. And now
Buon dia, professore.
Bom dia, como está, Francesca Di Pietro? Ainda tenho que responder a e-mail.
Tenho muita saudade de Lisboa.
Sim, infelizmente houve a pandemia e tivemos pouco contacto. Mas,
sì, por isso, não sei se pode vermi, eu sou no tribunale agora.
Consigo vê-la perfeitamente, sim.
I like this Portuguese moment.
Sobretudo porque o professor Ruggeri fala também português. Se eu não lembro mal.
No, yes. Tutte le
It's
lingue.
true, you're right.
Not just Portuguese.
Non parlo italiano.
You're using 3 or 4 languages. No, anyway, I would like just to say before closing that Francesca is now graduated and she's collaborating with the chair of philosophy of law, and she worked on a graduation thesis on the problem judgment with the support of Professor Paulo de Sousa Mendes when she was at Lisbon during her Erasmus period, but not just one period, one more than one period.
Yes.
And so on. So the collaboration is going on again, of course.
For sure, we will keep in touch.
Okay.
Yeah. I send to the professor the first and the second chapter of my thesis, and also for the exam of the PhD. He sent me a lot of articles about intelligence, artificial intelligence, and for this reason. So thanks.
Also,
if
also because, but I don't open the floor again, but consider that a lot of topics that have been dealt with in during our panel will be very interesting again and more if compared with the problem, with the issue of artificial intelligence applied to the problem of judgment, predictive justice, and so on. And so it is another topic. Okay. Thank you again to everybody.
Thanks to everyone.
Bye-bye. Bye-bye. Bye, Lucas. Thank you again.
Alessio, I'm allowed to return to your classroom.
Yeah, you are allowed. Yeah.
Aiutami. Ciao.
Bye
Grazie tutto.
Grazie mille. Arrivederci.
Arrivederci Costanza, arrivederci a tutti.